It looks like we've got people in. Good to see everybody. So welcome. I'm Dale Iverson, the moderator for the panel today. Our panelists this session are Tony Rahim, Ed Pappas, and Denise Langford Morris. You should see us. We're pinned, and so hopefully we're appearing up at the top. We wanted to be able to see your faces if we could. But if that doesn't work for you, that's okay. Our panelists' bios appear in your conference materials, so I'm going to mind our time and share a big thanks to them for offering keen insight from their breadth of experience. I'm pretty darn positive that's why you're all here, that you want to hear from them. And thanks to all of you for postponing lunch and digging in to discuss this topic with us at the tail end of what's been, I think, a really great conference, right? Quickly, our materials consist of 2 PDFs. Especially important for right this minute is the little 2-page scenario that the panelists will speak to. It's in your materials as a separate thing. It's also at pages 2 and 3 of our bigger set of materials. As far as I know, I haven't checked the chat yet, but we're posting a new link to those materials. So you can get at them without going back to your login page. If you can have the scenario open in front of you while we talk, that would be great. The larger PDF also contains brief materials from each of us on this topic, and also materials from a case that is directly on point from the Western District that was briefed and an opinion issued back in 2021, I'm pretty sure. In chat are some additional resources, including links to the standards of conduct and a link to the panel discussion from last year's conference that touched on this topic and was a little bit kind of an inspiration for this year. So I'm going to quickly offer why we think this topic is important for any mediator doing court-connected mediation. I'll then read quickly the background materials from our little scenario. Then our panel members will share their perspectives on pieces of that scenario generally and from unique perspectives from their careers. This is sort of my mediator opening, you guys. Get it? I'm trying to go really fast. We welcome chat for sure. If I'm hoping I'm going to get mine. There we go. Okay. We welcome chat for sure. I'm going to do my best, you guys, to monitor the chat with a special focus on, I'm going to try to pull out questions that I sense may not be addressed in prepared remarks. I'm going to hold those to our little question and answer period at the end, if that's okay. So my final bit of business here, why is this topic worth talking about? First, to clarify the topic, you guys, what do we mean by judicial interventions? Boy, that's an awkward set of words. What we mean is anytime a judge and mediator communicate or connect in real time, by email, by telephone, or text about the mediation before, during, or after a mediation session. This connection or communication could be initiated by the judge or by the mediator. To varying degrees, all 4 of us today have had experience with this in our practice as mediators, advocates, and judges, and all of the following could be true all at once. These interventions could be disastrous. They might even be prohibited. These interventions could be a valuable tool, even welcomed by some participants, and they might even be permitted. And also true, these interventions are not all the same, and some more or less dangerous, and some more or less valuable, and some more or less permitted and prohibited. So it's not clear that any of us today would respond to similar situations in the same way. So there's huge advantage, we think, in being prepared to respond to this challenge. And that's what makes listening to each other about this so valuable, and why we are so eager to share our thoughts and keep track of yours best we can. So with that introduction, you guys, I want to read just the very basic facts from the scenario that we're throwing out today for your consideration. So close your eyes, pretend this is who you are. You have been selected by counsel and parties to mediate an employment discrimination suit. Defendant employer is the local branch of a nationally prominent charitable organization. Plaintiff alleges racial, gender, and age discrimination in their termination. Court documents pertinent to mediation indicate that, and I'm quoting, parties and representatives with authority must participate in the mediation, and the parties must mediate for a minimum of 18 hours. This is real life, you guys. Upon receipt of the referral order, it occurs to you as the mediator that the case is complicated enough with enough parties and issues that you may need more time than 18 hours to work with parties and counsel. So first we're going to go to Tony. She's going to get us started, and she's going to tackle the pre-mediation challenges posed in the scenario that we're working from.
Good morning, everyone. As Dale said, I am going to talk about judicial intervention and mediation before the mediation session. I want to point out the key facts that I have tweaked a little bit. We are still in the employment discrimination case as mediators. We are concerned, however, because based on a pre-mediation call, and I think most of us have meeting, Zoom call or whatever with the attorneys before the mediation. So based in that pre-mediation interaction, the mediator is concerned that the attorneys are reluctant to commit enough time to mediation for it to be effective because the attorneys are afraid their clients will view them as weak. We're also concerned about that 18-hour minimum time to mediate set by the court. It seems as though the court may be intruding on the self-determination of the parties. So you decide without telling the attorneys to ask the judge to enter an order setting the time to start mediation, who should participate, and whether it will be in person or Zoom. And before you do this, the mediator, the judge contacts you about the same issues. Now, this raises 4 questions, at least 4 that I'm going to address today. Can the mediator contact the judge about these issues? Should the mediator contact the judge about these issues? Does it change your answer if the judge initiates the contact? And does it change your answer if the mediator asks the attorney's approval to contact the judge? The first guidance that I believe is appropriate is the mediator standard of conduct 1 on self-determination. It says a mediator shall conduct mediation based on the principle of party self-determination as to process design, and participating in or terminating the process. A mediator's commitment is to the parties and to the mediation process. A mediator shall not undermine party self-determination for reasons such as outside pressure from court personnel. That's standard of conduct 1B. I also looked at standard 7 about the quality of the process. It reads that a mediator shall conduct the mediation in a manner that protects the quality of the mediation process. To promote the quality of the process means that the mediator shall conduct mediation in a manner that promotes diligence, timeliness, safety, presence of appropriate participants, party participation, procedural fairness, party competency, and mutual respect among all participants. Next, I looked at the mediation court rule about scheduling of mediation. In MCR 2.411C1, it provides that the court referring the case to mediation shall specify the time within which the mediation is to be completed. Not the number of hours, but the time within which the mediation is to be completed. The mediation shall continue until a settlement is reached, the the mediator determines that a settlement is not likely to be reached, the end of the first mediation session, or until a time agreed to by the parties. And finally, we have the court rule on confidentiality that bears on this topic. This is a very simple rule, MCR 2.412, which provides that mediation communications are confidential. They may not be disclosed to anyone other than mediation participants, with a few exceptions. But first, let's make sure we all understand what mediation communications are. They include statements, whether oral, in a record, verbal, or nonverbal, that occur during the mediation process or are made for purposes of retaining a mediator or considering, initiating, preparing for, conducting, participating in, continuing, adjourning, concluding, or reconvening a mediation. Everything from the first thought to the very end. And also, it's important to note that a mediation participant means a party, a non-party, an attorney for a party, or a mediator that presents in or participates in a mediation. And the only possible exception to this rule in our employment law scenario is if maybe the parties were agree in writing that there can be a disclosure of a mediation communication, but we'll see. So now, getting back to the 4 questions, I'm going to apply these standards and rules to those questions. First question, what can the mediator contact the judge about, if anything? Well, there's no prohibition on a mediator getting guidance from or agreement with the court about things such as dates by which the mediation should start or end, but telling the parties what factors should dictate when they stop, such as how many hours they have mediated, appears to be outside the court's authority. Moreover, the mediator cannot tell the judge why they are contacting the judge, i.e., because based on the pre-mediation conference, the mediator believes the attorneys fear their clients will think they're afraid to litigate if they devote too much time to mediation, because revealing this impetus for his or her contacting the judge would be violative of the court rule that mediation communications are confidential. So those are things you cannot contact the judge about. What should the mediator contact the judge about, if anything? Well, the biggest should for mediators to protect the quality of the process and the self-determination of the parties. So the mediator should contact the court if they're convinced that there's something the court can do that will, without interfering with the parties' self-determination, improve the quality of the process. The court just has to make sure, or the mediator has to make sure not to reveal words, actions, impressions, or verbal or nonverbal that the mediator got from any contact with any mediation participant, since that would be violating the confidentiality rule. Next question. Does it change your answer if the judge initiates the contact with the mediator? No. The standard of conduct require that the mediator respects the parties' right to self-determination, protect the quality of the mediation, and maintain mediation confidences. Pressure from a court should never affect or undermine these basic principles. And then the last question, does it change your answer if the mediator asks the attorney's approval to contact the judge? Well, the only time the attorney's approval would be relevant in the context of our scenario would be when a mediator felt the need to disclose a mediation communication in their discussion with the judge. In that situation, if the parties or their attorneys state in writing that the mediators can reveal certain mediation communications, the mediator may do so, but they must still respect party self-determination and quality of the process. In conclusion, your key takeaways are as follows. In deciding whether judicial intervention before a mediation is appropriate, mediators should consider that parties are always entitled to have a say in the mediation process, that party self-determination should be more important than outside court pressure, that a mediator must balance party self-determination with the quality of the mediation process, that per court rules, judges can order the time within which mediation is to be completed, but not how long the parties must mediate it. And the mediator cannot reveal what went on in any aspect of the mediation to non-participants, except under very limited exceptions. And with that, I will turn it back to Dale.
Hey, thank you. Can everybody hear me? I do have my thing back on, right? Yeah. Okay. Well, Blown Away Part 1. Thanks, Tony. You got me thinking here. And I thought I knew what you thought. So now we're going to go to Ed, and Ed's going to speak to what might happen during the mediation, and even more broadly from his perspective as a mediator and advocate. If you look at the scenario, we're into the second part during the mediation. So take it away, Ed.
Thank you, Dale. And I do agree with Tony that the mediation standards of conduct are important to consider when interacting with a judge about a mediation in his or her case. For me, however, confidentiality is my primary concern and my primary consideration. To be an effective mediator, you have to earn the trust of the parties and their attorneys, because when you earn their trust, they'll be more open to new ideas and more willing to make reasonable compromises. One of the ways that I earn the trust of the parties and their attorneys is to pledge to them, both in a written confidentiality statement and in my opening statement, that anything that they say to me in the mediation will be held in confidence and not disclosed to anyone, including their opponents and the judge in their case, unless I'm specifically authorized by them to disclose it. One of the biggest mistakes a mediator can make is to disclose confidential mediation communications without the consent of the parties. Because when you do that, you will instantly lose any trust you may have earned from the mediation participants. I know this from personal experiences as an advocate in mediation, where the mediator disclosed confidential mediation communications from my client to their opponents or to the judge in the case. It's happened infrequently, but I know firsthand how a mediator's breach of confidentiality feels like a punch to the gut, and neither my client nor I could ever trust these mediators again. In those mediations where that happened, where there was a breach of confidentiality by the mediator, no settlement was reached in the mediation. And that's why, as a mediator, right in the beginning, pledge to the mediation participants that I will not disclose their communications in mediation to anyone, including their opponents if we're in a private session, and especially to the judge, who many of the people or the attorneys in my mediations know that I know a lot of the judges. So I want them to know that I'm not going to be disclosing their confidential information without specific consent. But this doesn't mean that I don't interact with judges on occasions in my mediations. Many judges are interested in doing whatever they can to help the parties resolve their differences in mediation. And there are times that the judge's assistance can be helpful. But I have 5 specific rules that I follow before and when I interact with a judge. First, I don't initiate contact with a judge in a case unless all of the parties and their attorneys in the mediation have asked me to contact the judge. Second, I don't disclose any confidential mediation communications to the judge unless all of the parties have agreed in writing. And when and if I am authorized in writing, when I communicate in writing to a judge, I copy all of the attorneys to the parties on my communications. Third, I don't make any misrepresentations to the judge, even if the mediation participants want me to. Fourth, if one party asks me to speak to the judge about something and the other parties say no, I don't speak to the judge. Because if I do, my neutrality may be compromised, and I certainly would lose the trust of the parties who said no. And fifth, if a judge contacts me about the mediation, I will talk with the judge, but I will only provide information that is not confidential and is permitted under the pertinent court rules and standards of conduct, such as the date of the mediation, who is participating in the mediation, and if a session of mediation has already occurred, whether there was a settlement or whether additional mediation sessions are contemplated. Sometimes it's a balancing act on how I comply with my personal rules and maintain good relationships with the mediation participants and with the judge, but I really haven't found it to be problematic. In a number of my mediations, parties have asked me to contact the judge to obtain an extension of the discovery deadline so that they can devote their time and money to efforts to resolve their disputes in the mediation. This occurs most often in more complex cases where mediation is going to involve multiple sessions and sometimes over a significant period of time. When everybody's in agreement, I usually suggest that the parties first file a stipulation or a joint motion for an order extending the discovery deadline. And I tell them if they want, they can state in their filings that the mediator concurs with the stipulation to allow the parties to engage in a meaningful mediation. I tell the parties that if the judge then contacts me, I will confirm my agreement with the extension of the discovery deadline for the purpose of allowing them to engage in a meaningful mediation. There's only one time that a judge contacted me for confirmation, but mainly to advise me that the trial date will not be adjourned. But that in that case, and in basically all of my cases where this happened, the stipulated order was entered. And many judges are concerned about extending a trial date, but in most cases, you're really able to extend a discovery deadline without affecting the trial date. This type of judicial intervention is extremely helpful because it allows the parties to focus on an amicable resolution of their disputes rather than engaging in discovery wars, where sometimes you end up drawing lines in the sand. Now, in a good number of my mediation, dispositive motions were pending at the time the case was sent to mediation. In some of those mediations, the parties agreed that a decision on a pending dispositive motion should be delayed until the mediation concluded, and they've asked me, or they did ask me, to recommend a delay to the judge. In these situations where there was full agreement, I again usually suggest that the parties jointly contact the judge and ask for the delay in the decision. And then again, I authorize them to advise the judge of my concurrence. In all of my mediations where this happened, the judges were willing to delay a decision to give the parties an opportunity to settle their differences. In a few of my mediations, the parties disagreed on whether to extend the discovery deadline or delay a decision on a pending dispositive motion or motions. Sometimes, most of the times, there are motions on both sides. In these mediations, I advise the parties that I would not contact the judge unless all parties agreed, because I need to maintain my neutrality and I don't want to give one party an advantage over the other. And as a practical matter, if one party wants to take certain discovery or wants a decision on a dispositive motion before settling the case, it would be highly unlikely that the parties would reach a settlement in the mediation before those events occurred. And I don't have any problem telling the parties this point because it's a very important point. But it also provides an opportunity for a mediator to mediate issues relating to these events, such as what discovery do you need to make meaningful compromises in the mediation? And can we limit the discovery and the cost and the time before the mediation session so that you can both come back and you have the information you believe you need to make a meaningful decision? In all of my mediations, I've only had one judge contact me to ask questions that would have led to the disclosure of confidential communication. And that was long ago when the mediation rules were first adopted. But after I explained to the judge the confidentiality rules and my obligations under the standards of conduct, the judge did not pursue these questions anymore. And the point I'm making here is that most judges are well aware of the confidentiality rules and will not be asking mediators to violate those rules. So I'll conclude my initial remarks by saying that interactions between mediators and judges can be useful if all the mediation participants agree, and if the interaction will assist the parties in resolving their disputes. So it's just another tool that mediators have in their pockets. And I'll turn it back to you, Dale.
Thanks, Ed. Okay, another important piece of the puzzle. It's all becoming clear. So I'm gonna commend on behalf of the group. I'm gonna commend you to look through those scenarios. Those are taken from our practice experience. Not everybody's had the same ones, and those might be some stuff you want to toy with and think about. But now we're gonna come to a relatively newbie, super involved in this section, and that's retired Judge Denise Langford Morris, who's now a mediator and arbitrator at JAMS. And before she talks with us, maybe about scenarios even more broadly from her perspective as a judge and a newer mediator arbitrator, we want to congratulate Denise. She just recently, within the last week or two, ascended to the chair of the ABA Judicial Division, National State Trial Judges. So that's an exciting thing on her horizon, and where she can learn a lot about nationally about where judges sit on all of these questions. Denise, that's going to be your topic for the conference next year, what you're learning from all those judges. So anyway, I want to hand it over to Denise. It's so good to have you here.
Thank you so much, Dale. I just want to correct, I got elected in Denver at the American Bar Association annual meeting as the chair-elect for the National Conference of State Trial Judges, one of the conferences of the Judicial Division. So I will automatically become chair next year. But thank you so much for that warm introduction. I am honored and privileged to serve on this panel as a relatively new ADR professional. I've known Tony and Ed for a very, very long time. I've worked with them on various committees, and I just met Dale, and she is phenomenal. She has kept us moving forward. So thank you again. And with the help from Marianne Parks, we really have enjoyed preparing for this presentation. My perspective in general, after 30 years on the bench, 40 years as a practicing attorney, leads me to say that I am speaking on behalf of myself, not the ABA National Trial Judges, nor JAMS, But I've learned a lot in a little over a year as a mediator. And this topic is near and dear to my heart. I was blessed to serve on the Oakland County Circuit Court. It was a great court, lots of resources. And I failed at retirement. I was retired for a weekend and started at JAMS. And it's been an honor to serve as an ADR professional at JAMS. There are many similarities and many differences between the role as a judge and as a mediator. As an arbitrator, it's a little more similar to being a judge. I have more arbitration cases than I do mediations, and I want more. But we all know that judges are powerful and they rule inside their courtrooms. Judges generally care about doing a good job in the community and dispensing justice, maintaining the rule of law, and they care about their reputations. But importantly, judges love it when cases settle. There's a lot of pressure on members of the bench. The volume of cases, the huge dockets, the timelines imposed, the backlogs based on COVID. They must keep the docket moving and eliminate delay. And so if you don't do that, you're going to get a call from the chief, not to mention the pressure of full-blown elections that we have here in Michigan that you're supposed to disregard. I will say that all these reasons and more are why judges need mediators and mediation. It keeps the dockets moving. And you can't go to trial on all the cases. When I first started, I was getting over 2,000 cases a year, civil, criminal, and family and appeals. And then when I left, we were getting almost 1,000 cases per judge in the civil criminal division. So Tony and Ed have queued up the standards. And the major concerns are confidentiality and party self-determination protection. As a trial judge, I communicated with mediators all the time. I received requests, usually by email, to extend discovery deadlines, hold off on ruling on a motion for summary disposition, or even on occasion to hold off on trial dates. Mediators that contacted me, these were great mediators. Some of them were former judges, some of them weren't, but they always copied the parties on the request. I would receive requests sometimes late at night on an email, and I would respond to the mediator, and I always copied the parties. I never recall denying a request such as this from a mediator, because I always had plenty of other cases and things to do. So judges are generally concerned and have a lot of control over when a case can get to trial versus when a case will actually settle during a mediation. We all know the cost of litigation, the length of appellate delay, and the stress from that delay. And so trust makes all the difference in the world. The parties' and lawyers' perceptions regarding communication between the mediator and the judge is crucial. They worry about a negative reference or their performance if a judge were to possibly communicate with the mediator and they not know it. And I agree wholeheartedly with what Ed was saying about asking for permission from the parties in writing, even if I only get a text from the lawyers. I would get that, not necessarily from the parties, but I would want an agreement. And I generally give my cell number and communicate by text as I'm going in and out of the rooms during mediation. I've even actually concluded with setting up agreements by text, but it's interesting. But I did meet with the mediators, as I've indicated. I rarely would hold off a trial date because I have Hilda Gage, the great Judge Hilda Gage, in my ear. Never delay, never delay. because that pushes settlements. But I never reached out to the mediator to inquire of the status of a case. I believe very strongly in the confidentiality and self-determination as outlined by both Tony and Ed. But as I spoke to many judges, and I kind of did my own informal survey as I was preparing for this presentation, and as the chair-elect of the National State Trial Judges, I've been at several conferences this year. And so I started inquiring of judges informally. They shall never be named. Some of them were local here in Michigan and some nationally. And I discovered that although not that many mediators reach out to judges, there are some judges that reach out to mediators, particularly when you're looking at mediators that are former judges. And that's what I want to share. I'd say the bulk of those that I spoke with did not reach out to the mediator, but there seems to be a prevailing number of judges that will reach out to the mediator. There are differences in experience level with judges. There are many judges that have never conducted a mediation as a party, representing a party. And there are many judges that are relatively new to the bench. As we know, there's no requirement for expertise when you take the bench. The only requirement of 5 years of licensure. You could have worked at McDonald's, but if you have been licensed for 5 years, you can be a judge. And so some judges apparently, and this is what I've heard from mediators, particularly those that are former judges, that some judges will reach out to a mediator. And many judges feel more comfortable answering that request or reaching out. It depends on the judge. But there are some judges who have never had a trial or never been in trial or never mediated. And so if a judge trusts the mediator, let's say the mediator worked together on the same bench with that judge, grew up together, attended law school together, or maybe best friends. And let's say that relatively new judge wants to know what they should do to move the case along for all the reasons that I shared earlier. The dockets are heavy, COVID took a drain on the court system, and so they want to figure out how to push it. I could go on and on about what I discovered. Some judges, former judges rather, mediators shared that they get calls all the time from former colleagues. What can I do to push this case along? So this is an ethical balancing act. Judges like settlements and judges need settlements. There are thousands of cases, little resources, and few judges are like those in Oakland County and the federal bench, where we have 4 full-time staff members that only work for us. So this is the good, the bad, and the ugly. And my conclusion is that this sector, this discussion, is at a judicial crossroads. It's an area that will continue to evolve as we all work together as ADR professionals and judges within the justice system. Many years ago, I had the privilege of working on the Judicial Crossroads Task Force with our chair, Ed Pappas, and the family court and the business courts evolved from those sessions. There may come a day when confidentiality is limited by caveats with a goal towards the ultimate resolution of more and more of these civil cases. And I'll end there because you know I'm a lawyer. I could go on and talking, Dale, but I'll turn it back to you.
You guys have done an amazing job. I've been using my little stopwatch thing on my phone, and we're right on track. Although we're a little pressed for time. So I'm going to offer this. What we plan for everybody is for our panelists and even me to get a chance to make little closing takeaways. And we're at the point where we sort of got to do that now to fit it in. I'd note that and so I'm gonna leave my questions we generated, set those aside for now. I noted that Ann Bockley Pfeiffer raised a really good question about a strategy that I'm sure she and others here use to sort of massage this issue. And her question was about working with the parties and the lawyers to get them to approach the judge. I think I have a sense of where you all would fall on that. So I'm going to let that go. We're gonna offer takeaways. Here's my takeaway to everybody, and then I'll be quiet like a good moderator should be. You guys, in our big PDF at the end, it's probably the last 20 pages of that, is a fantastic discussion, in my opinion, of what we've talked about here, but they're going deeper because they had a dog in the fight. And that's, we've included the briefs by the state, the AG's office, and by Enbridge in their ongoing litigation. They had a question about mediator contact with the judge during the course of their case. And the Judge Janet Neff from over here, actually reached a decision on this very issue. And so between the three of them, among the three of them, they just raised some phenomenal stuff. The only other thing I'd add, you guys, is this group of three has really focused you on important considerations in making this decision: court rules, confidentiality, standards of conduct. I'd add two more. And as it turned out, they played a role in that Enbridge decision, and that is the program rules for whatever mediation program you're working in. It turned out that was where Judge Neff landed, is what did the program rules say? And number two, the other thing is your retention agreement, which is a contract. What does that say about, if anything, about contact with a judge? And I'd also wonder, I'm hearing it a lot in what Denise was talking about whether there are any implied contractual understandings where you're mediating, an advocate is mediating with somebody they know well, and they think and understand a mediator would go ahead and do certain things. That's an implied contractual provision. So with that, I'm going to stop. Tony, take away from all of this and what you've heard. It's so good stuff.
Well, I gave some takeaways earlier, so I don't want to repeat myself, but I'll just say briefly that while for me, starting with the rules of standards of conduct and the court rules is critical, there are always, well, not always, but oftentimes another step about what you can and should do. So there's the things you can do according to the rules, and then there are things you should do based on things like trust, as Ed talked about, things like having a relationship with the parties or with the judge, and a multitude of other things. But I would just emphasize that start with the rules, and if you can, then ask yourself next, should you? And that's it.
How about you, Ed?
Well, I'll just mention a couple of quick things. That Judge Neff in that decision on the Enbridge case really had one sentence in there which I thought was pretty important. It said, voluntary facilitated mediation necessarily requires voluntary participation by both parties. So even when mediation is required or ordered by a court, it's still a voluntary mediation. In other words, everybody has to want to participate. And sometimes they come in and they're not ready, but after they are into the process, you can see them more interested in it. But the bottom line is, it's up to the parties who are in the mediation whether they want to settle a case. It's not up to the mediator. It's not up to the court. And I follow that direction in almost every decision I make as to whether or not to continue a mediation, to contact a third party for help and the like. So I think that's just something important to keep in mind. And I saw real quickly, I think Shell Larkey was asking Denise, and she can answer this question herself, whether it means that people shouldn't hire former judges as mediators. And the answer is that yes, they should, but people need to know right in the beginning, because as an advocate, if I knew that a mediator was inclined to talk to judges, including about substance, I wouldn't hire the mediator right away. But most, as I mentioned before, most judges know this rule when they're on the bench, and most judges would be very careful about talking to judges afterwards. So it all depends on the particular mediator.
Thanks so much, Ed. Denise.
Well, quickly, I never talked to a mediator about the status of the case, and I've never reached out as a mediator to a judge. I would never do that. So I don't think there's any problem with hiring a retired judge, of course. But I will say this. I recall that one former, well, he's a present mediator, but he never was a judge. And he said that you can put into the actual mediation order that the mediator can contact the judge and keep the judge apprised of the progress. And I note that in Oakland County, I recently had to complete a mediation form that they use. And it asked, luckily the case settled and I didn't have this issue, but it asked, which party refused? Did anyone refuse? And that's on the form order that you must file within 7 days at post mediation. And so again, there are a lot of things that are going on with this issue, but I would say that my final takeaway is know your judge.
Okay, well, thank you so much, you guys. And I was going to just say that Oakland County status report, it's not the one posted on the Oakland County website, but there are, because I just got one of those on a case that I've got in Oakland County. And I don't know if it's one judge, but different forms. People, I can understand the desire of judges to get creative about how to use those forms to help move cases, but they raise really interesting issues for us. What a panel, you guys. Are they phenomenal or what? I know you're all applauding. You don't have your cameras on, but they did. It was awesome, you guys. It was just awesome. So interesting. All these really awesome perspectives. So I know that everyone's eager to go hear our new ADR section. You guys, she's only been chair for like an hour. So go listen. This is important. And thanks so much for being with us today.
Thank you, Dale. Great moderating.
Thank you.
Thank you.